Here we've got a view limited against the Appeal Commission and another.
Mr. Cordaro, Mr. Rowe, good morning. The appeal has changed complexion somewhat since the written cases were lodged. Yes. And I think it would assist us at this stage if we could hear from Mr. Rowe in relation to precisely what is accepted and what is not accepted in relation to the appeal. And at some point, we'd like to hear you both, in addition, please, in relation to the question whether any remittal should be to the Appeal Commissioners or to the High Court, and what the significance of that and the powers of the two bodies.
Yes. My Lord, so far as the area of controversy that I've called element 3 in our written case is concerned, that is to say the temporal aspect, when income is treated as accruing, yes, is concerned, I don't think there's any change in the complexion of the appeal, and your Lordship and your Ladyship see that we essentially say that the courts below got that part right, and I think our learned friend says they didn't. The change really is in relation to elements 1 and 2, in other words, sections 23 and 66. What it really comes to, my Lord, is this, that the decision of the controller, as the board will have seen, was based on the proposition essentially that this was a sham, and that there was really no insurance business going on at all. This was simply it was put to the controller, I think, in cross-examination. Are you saying effectively that they've put their heads together to come up with an appearance of something which is not really happening? And he said he was saying that, and that was the basis of it. And in the light of the judge's finding,
well, I'm just sorry, and it followed therefore that the whole amount would be assessed to tax.
According to, on the controller's original, yes, on the sham basis,
there would be no...
yes, the position would be yes, the income was received, and therefore, since none of it was deductible on the basis that it was insurance premiums,
it would all be taxed.
It would all be taxed. That was the basis of the.
So it was simply a ruse to transfer profit to a lower tax jurisdiction.
I don't think that's spelled out, but essentially yes, that's my lady, that's right. We, having looked at it and looked at the way in which the learned judge looked at that issue, have been driven to the conclusion that we can't support the way in which the courts below dealt with that. Because what the learned judge did at first instance was essentially to say, well, I find this wasn't a sham, it was a real insurance transaction. Yes. But nevertheless, the controller was entitled to maintain the position that the controller had maintained, and it's not my job to do the appellant's job. Not my task, my role to do the appellant's job for them. But one can see that there is perhaps some difficulty in the reasoning there. So we therefore don't seek to defend entirely the judgment below. What we've said in our written case. And I was reflecting upon this again this morning, as one does, is that we don't resist the appeal as it relates to elements 1 and 2. I suppose that's perhaps a slight oversimplification, which no doubt has given rise to the board's questions, because effectively the options, I suppose, in those circumstances would have been either these. Given that it's accepted that the decision falls to be set aside, because it's based on reasoning which is inconsistent with the judge's findings of fact.
Which decision? The controller's
The controller's decision. Yeah. The question then arises: well, what should be done? We could, I suppose, have said the appeal should be dismissed on a respondent's notice point, effectively. That although the controller's reasoning based on the sham argument can't be sustained because of the judge's finding that there was no sham, nevertheless, the board should find that Section 23 is engaged. I'm really talking about Section 23 point rather than about withholding.
I thought that is what you were saying.
That is what I'm saying. The question, I suppose, really is as to who we are asking, who ought to make that decision. And in our written case, we've suggested that.
Is it the assessment that's set aside?
Well, when one talks about setting aside, I'm addressing it in the context of how one looks at any appeal against a decision. The reasoning is set aside. Can I put it that way? Of the controller, which I suppose in a sense does mean the controller's decision gets set aside.
The
It
controller's decision is that that amount of income is not deductible and it's to be treated as income and subject to profit, right? The reason that he said that that was the result was because initially he said it's a sham.
Yes.
Right? Now you say you accept that it wasn't a sham, but what I think we're looking for is whether you still say actually the assessment in terms of the figures as to what should be taxed and what shouldn't be taxed is still right, correct, but the reasoning is different because Section 23 still applies because of the abnormalities that you identify. Is that what you're saying? And that, or
Sorry, I don't think you can say that,
right.
because it's only because you said it was a sham that the whole amount could
that's
be
what we're trying
taxable. So it seems to me, if you're saying that the controller was still entitled to assess under Section 23 because of the abnormalities you rely on in relation to the transaction, then it may be that the amount of the assessment is wrong, and that would have to go back. And that
Possibly,
is
yes.
because of the reasoning being now held
Yes.
to have been flawed.
Yes, I mean, our essential point is that the fact that the sham argument has gone away, or the fact that the sham reasoning of the controller's decision has been taken away by the judge's decision, doesn't automatically and inexorably lead to the conclusion that the decision was in every respect wrong.
Yeah.
The question then becomes, well, that was an answer you gave for the wrong reasons. What's the right answer?
But the controller doesn't get the chance to have a second go and raise a new assessment, or does he?
We're not proceeding on the basis that he does. I think we've taken the stance that the right in these circumstances, it having gone to the appeal commissioners, it would be a matter for the appeal commissioners, as the specialist body, who deal with things on a de novo basis, to decide what the right assessment is.
So they deal with things on a de novo basis. So they could say yes or no, Section 23 applies for your new reasons, and that let me call it the kind of the counterfactual which the controller has to come up with under Section 23 when he finds there's been an abnormality. He then has to say, right, well, putting aside that abnormal transaction, what would have happened normally and what would be the tax consequences. And as my lady says, that may be that actually some, although not all of the premiums are genuinely deductible and some are not, rather than everything not. But you say the appeal commissioners can make that decision.
Yes.
Which is the decision which is under Section 23 given to the controller to come up with the counterfactual and then assess on the basis of that. But you say the appeal commissioners can effectively do that.
I think that's my submission, lady, yes.
And just as a matter of interest, why do the appeal commissioners not make findings of fact?
In the present case?
In the present case. What, is that just a strange feature of this case, or is it normal?
I would have to take some instructions on the extent to which this is typical
Right.
in this jurisdiction, I'm afraid. But your ladyship is, of course, quite right that they don't seem to have made many findings of fact.
I wondered if
We
there were some missing
have a very
pages.
short document. I don't think there's any I don't believe there's any missing document, a lengthy reasoned judgment that we've not seen.
Right.
I could be wrong, but
That was just out of interest.
I'm afraid it's not a question I'm in a position to answer at the moment, but I will endeavour to get some instructions so I can see whether I can.
But if it just goes back to the High Court, can they also decide whether your Section 23 abnormalities do bring it within Section 23 and also then construct a counterfactual counteracting those abnormalities and make an assessment or not?
The problem with going back to the High Court, as we understand it, my lady, is that its power rather is limited to hearing an appeal from the appeal commissioners, which involves a question of law, albeit it goes on to say including a question of mixed law and fact. This is, I don't know if the board wants to turn it up. This is right at the end of the main electronic bundle, starting at page 2555, I think, 2555. Section 104 tells you that if you don't like what the controller has done, you go to the appeal commissioners. And then section 105 tells you that the appeal commissioners have got power to confirm, increase, or order the reduction of any assessment, or make such other order as they deem fit. And then 106 is the right of further appeal to the High Court from any decision of the appeal commissioners which involves a question of law, including a question of mixed fact and law.
But the appeal commissioners hear it afresh. Yeah.
That's as I understand it, yes, they do. So it comes to this essentially, unless the board is persuaded that actually there's as my learned friend will no doubt say, there's a completely clear answer, and all of these deductions are simply allowed, full stop. And there's no withholding tax to be paid, then the question arises, well, what's the right answer? And it therefore follows we've got to find somebody to give us the right answer. And of the possible options, namely the board, the High Court, or the appeal commissioners, it strikes us that the appeal commissioners are the most sensible answer.
Thank you. Mr. Carrara.
My ladies, my lord, you will not be surprised to hear that we respectfully disagree with that analysis. We have exercised our right of appeal under section 104, to which my learned friend referred to. That's EB 2555. And the controller... Yes, I apologise. I was walking around too much. Certainly.
Sorry about it. I just want to switch over. That's right. Yeah? If you've got to come right over, just go.
That's fine. Thank you so much.
No, sorry about stopping you.
Not at all. Not at all. So we've exercised our rights of appeal under 104. Both parties had whatever opportunities they wished to take to deploy their evidence and arguments before the three levels of justice in St. Vincent, and the suggestion that there might be secondary or alternative arguments that the controller has not yet run is one that we would urge the board to reject unless there is some possibility of new evidence and so forth, which is clearly not the case here. So everyone has had their fair crack of the judicial whip. The controller could have run a secondary case, he could have cross-appealed, or he could have sought, rather, to support the decision of the Court of Appeal on alternative grounds, and we would have therefore been in a much clearer position today to understand what might be left over, which we submit is nothing. What we are discussing at this point, indirectly or perhaps directly, is the extent of an issue estoppel arising out of the decision of the board at the end of this hearing. And what I mean by that, I mean in connection with issues 1 and 2 if I've understood my learned friend correctly, his suggestion will be that the only issue estoppel will be that there was no sham. But there will not be any issue estoppel as to the other alleged irregularities. We would urge upon the board that we've had ample evidence across the board on all of those points. We don't seek to lead any additional evidence at any level, judicial level. The Commissioner has not, I think probably very properly, if I may say so, indicated that he wishes, the Controller, that he wishes to lead any additional evidence. So the board is entirely seized of the factual and documentary landscape. And if the position of the Controller is that he doesn't resist the appeal, then all the necessary implications for res judicata, indeed, flow from that, and that would mean that the decision is set aside, the assessments that hang off the decision are quashed. The decision letter is at electronic bundle page 90, and the relevant part of that for these purposes is paragraph 1. It's the letter dated the 29th of March 2017, and it's the related party point, the point that in the, this is EB page 90, the related party point is that there were shown in the corporate filings as being paid to a related party the premium. And you will be familiar with that, having looked at the record of proceedings. And it says in para 4 of the first numbered paragraph on page EB90, and I quote, "Additionally, an examination of the supporting records and submissions strongly confirmed that United Insurance is merely a conduit and the substance of the payments is to the benefit of Canterbury Insurance," end of quote. So sham is woven in, perhaps, to the related party point. Indeed, it's very difficult to pluck out any thread from...
But the appeal isn't against this decision. The appeal is against the assessment.
My lady,
this is the underlying reasoning.
But it's the assessment that is...
It's the assessment that is appealed, and the assessment is you are to be assessed under sections 23 and 66 of the Act. And unless you can say that there is no basis for any assessment, isn't there still potentially something?
No, not at all, my lady.
Okay, well, can you explain that?
I do say that there is no basis for any assessment.
Yes.
I can't shoot at the universe in general, but I can certainly respond on the points that are the so-called related party point, which is perhaps still in play. The position there, the first stopping off point, is the statement of facts and issues at EB 1071 at paragraph 583, where it is accepted 8 Roman 3, but perhaps I can quickly read the whole thing. It's very short. Regarding the actual physical cash movements between the various parties, premiums paid by the customers were collected by the appellant. 2, the premium, net of claims and commissions, was paid by the appellant to United. And 3, the reinsurance premium was paid by United to Canterbury. Subject only to the risk of insolvency of Canterbury, United passed on both 100% of the risk and 99% of the net premium. So,
and is that what's been described as the credit protection insurance?
Yes.
Because sometimes it confused me. It's described as Unicomer being insured for the credit risk. But what you're talking about is always it's the customer who takes out the insurance, and that protects both the customer from losing the fridge or dining table or whatever if they can't keep up the premiums, but it also means that Unicomer knows it's always going to get the premium, the instalments under the hire purchase contract from the customer.
My lady has summarised it accurately, and I'm familiar with that initial confusion myself, but that is exactly in
There's
economic...
no other insurance of which Unicomer is a more direct insured, I don't think.
No, it's all packaged up in that relationship. So the related party point, which it may be that my learned friend is seeking to keep afloat,
Well, he is.
he is indeed, is first of all up against the acceptance in 8 Roman 3, which I have just read to you.
Well, except that isn't the argument that United was passing it? It was either going directly to Canterbury, and there's some evidence of that in your own financial statements, or it was going to Canterbury via United.
Well, Canterbury as a reinsurer, I mean, the it in that sentence obviously is
it is the 95% of the premium.
Exactly, but that would be true in any reinsurance chain.
Yes.
It won't be the self-same.
The amounts
dollars.
may not be.
Exactly. Well, the amounts won't be exactly the same, but of course you've got a primary layer, a primary insurer receiving the premium, and it turns around and passes 95% less set-offs down the line.
Yes.
And the fact that it is done according to the contractually agreed chain is, we say, a decisive bar to any suggestion that there is any residual reason to suspect some kind of improper behaviour here, because that pattern, that fact pattern, is indistinguishable from every normal and honest reinsurance chain.
But was there any direct evidence below as to the actual movement of funds?
As pointed out later in as pointed out in my learned friend's case, there was not evidence of the direct movement of funds. But the question is, why not?
Yeah.
Because the controller conducted an in-depth audit. It came, obviously, in the normal way, very properly, to the taxpayer. Everything was available to him, and if, as was evidenced, Mr. Pompey did not ask to see the bank accounts, then that was his choice. We say, had he asked to see the bank accounts, he would have seen the direct movements of funds.
But you could have produced that
Yes.
if you'd wanted to. In the appeal, it was your appeal.
Well, except that, yes, indeed, but nothing was made until the footnote in the respondent's case before the board of the lack of that evidence.
Well, is that right? Wasn't there an affidavit before the High Court in which the controller said that this was a feature of the abnormality that he was relying on?
I'm not sure.
There's a passage that's quoted by the High Court that sets out, is it 64 or not 64? Sorry, give me a moment.
When you refer to bank accounts, you're meaning you could have shown the bank account of Canterbury saying, look, there's no receipt of this amount on that date, and you could have shown the bank statement of United saying, look, they actually got this amount that's recorded as going out of Unicomer's account.
Yes, I accept that.
Yeah.
But the case we had to meet was that it was revealed in some way that by the related party comment that there was some kind of, well, we had to meet the case of sham.
Well, sorry, I'm so sorry to interrupt.
Oh.
It's at paragraph 53 of the High Court judgment, e-documents 114, quoting from the affidavit filed on behalf of the controller, and it's subparagraph 5 quoted there, where he says the balance after consideration of the claims, consisting of 87.8% of the premiums net of commission, were sent by Unicomer to Canterbury either directly or through United. So it was open to you to adduce evidence to show that no, they were never sent.
We called a witness
Yes,
who denied it,
and
he wasn't challenged. I'm directed to EB 371. If you just bear with me for one moment. Yes. So there was the failure to cross-examine. We also led evidence.
371 is a letter
Is a letter from
confirming receipts of premium.
Indeed.
Yeah.
So that's arguably at least as good as an evidential source as seeing bank statements, which in any event would have needed a narrative. And this is the letter of the 23rd of November 2016, and it's from the primary insurer, and it's difficult to know what more.
Well, but this is monies received from customers, I would have thought. Not saying it's money received from Unicomer, isn't it? This is saying this is what the customers have paid us.
My lady, there's no distinction in this sense that the customer's money is left with my clients, Unicomer. They go off with their sofa. We then, as cover holder, we being Unicomer, send on the premium monies to Massey, with whom we, Unicomer, as cover holder, stroke intermediary, have the relationship. The customers don't go away and independently send anything to the insurer, Massey, whose document this is. They simply pay at the till, I presume, what is asked of them for the product, including the insurance. But all monies are funded both to and through Unicomer to Massey, and if there is a claim, from Massey to Unicomer acting as trustee, again as cover holder.
So these sums, less 5% handling costs or whatever it was, would then go straight on to Canterbury?
Indeed.
Okay.
And
that would be the total amount. There wouldn't be other amounts that went to Canterbury
no,
separately?
There would be no reason.
So Unicomer, on your case, never paid Canterbury directly?
No.
And that then leads to why the financial statements described payments going directly to Canterbury as a related party over a period of 8 years, yes. And your explanation for that having been rejected, which I would have thought is an issue estoppel against you.
Well, the position is that the evidence is slightly more nuanced, my lady. The evidence of Mr. Miller, who explained it all, is to be found at EB 439 at paragraphs 7 and 8.
Sorry, 439?
My lord, 439 paragraphs 7 and 8. So that is his witness statement or his affidavit, 439 paragraphs 7 and 8. And I'm showing this to you. This was obviously his written evidence, where he says at 7, my response to the foregoing suggestion, which is what we're debating at the moment, is that the CPI premium payments were incorrectly classified in the financial statements of the appellant as monies payable to Canterbury. Such classification is wholly inaccurate and doesn't constitute a true reflection of what actually transpired between the relevant parties. It is this incorrect classification by the appellant's auditors which would have led Mr. Pompey to mistakenly conclude that the payments for CPI were made directly by the appellant to Canterbury when the actual reality and legal relationship between the parties established to the contrary. And he goes on, it's quite clear what actually transpired among the appellant United and Canterbury is that the CPI premium payments were made by the appellant to United as the insurer, and United in that capacity reinsured this liability with Canterbury. And then he refers to the contractual documentation.
So those CPI premium payments are payments that the appellant has collected from its customers.
Yes.
For their direct relationship with the insurer.
Precisely.
United.
Precisely.
And then you say, actually, it paid Unicomer paid them back, or paid them over to United, and United then paid 95% of them to Canterbury. But I think the judge, as the point that my lady was making, the judge found that that wasn't right, that they had actually gone directly from Unicomer to Canterbury, although that didn't prompt her to find that the whole thing was a sham.
No. Two points. First of all, that evidence by Mr. Miller, which I've just read to you, he was obviously then cross-examined, that evidence went unchallenged.
No, it didn't.
Oh.
The judge rejected it.
Forgive me, it went unchallenged in the shape of cross-examination.
Oh, I see.
I'm
so sorry.
I'm at the granular level,
I'm so
forgive
sorry.
me. So at a granular level, he went into and out of the witness box, and that evidence was not challenged. And I'm slightly off my own map in terms of the way to approach these things. But if evidence is not challenged, then it must be treated as having been true, unless there's some excuse for not having challenged it. So insofar as her ladyship, despite, or perhaps forgetting, if I may say so with great respect, that the evidence was unchallenged evidence, reached the conclusions she reached, then that was clearly a conclusion which ought not to have been reached.
Was that a basis of appeal to the Court of Appeal?
Well, we've appealed her decision.
But
it's not as if we were supine in the face of the decision. And in fact, we did say we said to her ladyship, in the wake of the closure of the evidence, but before she made her decision, this is at EB 570, EB 570. What you will find at EB 570 is our written submissions.
Written closing.
Well, written closings. And
summarising Mr. Miller's evidence there.
yes. And 7 to 11, 570, 7 to 11. And at 9, we say, however, I'm looking at page 570, EB, what's most instructive or significant is that no attention in cross-examination was directed to challenging the evidence appearing at paras 6 to 10.
And that includes 7 and 8, which you just
Exactly.
raised.
So we could have done one extra thing, which is produce the bank accounts, but we produced the Massey letter, we produced a witness who denied it, we produced a contractual chain which was inconsistent with it, and this is the other point I'd like to make, we mustn't forget that we're dealing with insurance companies here, and I say that simply because they are, as we all know, highly regulated, and they therefore come under enhanced scrutiny for obvious reasons. as to their accounting practices and the receipt of premiums and what happens to premiums and so on. I accept that this is just a broad brush point, but we're not dealing with street traders, we're dealing with corporate entities that have to document everything and whose bank accounts, no doubt, if necessary, will be scrutinized by their regulator, and who, if the regulator sees a book of business being written with no apparent premium coming in, will question it. It's difficult to divine any conceivable motive for those in the reinsurance chain to cooperate with some kind of arrangement whereby the premiums didn't go along the chain. And we know from the Massey evidence that I've just
And it may be said that even if they did go along the chain, this was an arrangement that enabled two related parties to pass on an abnormal amount of profit.
My lady comes to the second point,
Yeah.
which
Well,
I would come...
Remind me where that letter from United...
I think it was 571. Is that right? 371.
Oh, right.
My lady.
371.
23rd of November 2016.
Sorry, I interrupted you.
Oh, I see. Just give me a pound.
Transcript.
My lady put to me the possible disguising of the abnormality. The abnormality point I will come to very shortly. My learned friend didn't mention it, but it's in the air. It's been put in the air now by the respondents, so I do need to come to it. But if I can just park it for a moment, just come back to the basic thesis. The basic thesis is that the money didn't go down the chain. It went sideways directly from my clients to an overseas location, namely Canterbury, offshore. The Section 66 challenge, of course, is directly dependent upon that money movement having occurred. And everything I've said up to this point applies with equal force to the Section 66 point. As to the, I may just come back briefly to that in a moment, but can I come to the this rather troubling suggestion made out of the blue in the respondent's case that, I think it was paragraph 12, that there is something fishy about the level of profit which is involved in the arrangement. And I refer in the key documents to page 64 in the electronic bundle to 1131. And this came as something of a surprise to those instructing me. It's described as a curious aspect of the transaction, and an assertion is made that it was excellent business. There are no inverted commas, but they're clearly implied, and that there was something abnormal about the levels at which the premium was charged. We were surprised to see this at the appellate level, since, as far as we can recall, there was no suggestion at any stage that this product was other than, at least within its four corners, commercially normal. Our response is as follows. We've 5 or 6 points to make in response. The first is this possibly reveals an ongoing or an enduring lack of understanding of the type of insurance product with which we are concerned in this case. It's sold, as we all know from our personal experience, in a retail setting to a customer whose principal aim is to acquire goods normally. He or she is standing at the till, and there is therefore an opportunity for the sale of insurance products. The customers themselves, obviously, we're at arm's length, and to the extent that the premium quoted is too high, whatever that means, they are free to go elsewhere and acquire their sofa from others. So, point number one, we are dealing with a product whose pricing is exposed to ordinary people, and I'm authorized to say these are people who do not have abundant discretionary funds. They will be careful about what they spend. The second point we make is that there's absolutely no supporting evidence, direct or indirect, of this assertion. We don't know where remarkably expensive comes from. Those words appear in the last line of 12. The controllers had many years in which to construct a case against us that it is remarkably expensive. No comparator appears, nor, as far as I know, is any to be referred to now. So it's difficult to know what to make of it, but it hasn't been, no foundation has been laid. The third point is that where one has captive insurance of this kind, we can put the fronting aside. The fronting is just an accident of whether or not the insurers in the chain are regulated in the relevant jurisdiction. As you can readily appreciate, the Caribbean has lots of economically small jurisdictions, and it is very difficult for insurance companies to be regulated on every island. Indeed, it's probably, generally speaking, the world epicenter, if we include Bermuda, of reinsurance, but that's of a much broader type. So reinsurance is endemic, and in terms of fronting, that will be particularly acute as a need in a highly fragmented regulatory market. My point, however, is about the use of captives for this kind of business. There is a clear commercial opportunity, which is worldwide, is recognized to sell insurance, and that is what happens. And if the insurance...
Right, so can you just explain what you mean by a captive in this?
Indeed, and by captive I mean within, such as Canterbury, within the same corporate group as whoever is, say, selling the sofa on HP.
But United isn't in the same corporate group, but the reinsurer is in the...
So my client Unicomer, who sell the sofa, including an insurance policy, they are in the same corporate group as Canterbury.
Yes.
And that's a very common situation, because it means that the corporate group can share in the profit, but of course also the losses that come from insurance attaching to their goods and services, and it's usually goods that they sell. And that is a perfectly normal arrangement. They keep the benefits and the burdens of the insurance within the corporate group. So you've got your furniture stores, and then somewhere else in the corporate group you've got your regulated entity. And the furniture stores often directly simply have the captive. You make 2 contracts at the till, and you leave. We've got fronting because we're in a regulatorily fragmented part of the world, and the corporate captive insurance could not write. that business in St Vincent.
Because it's not regulated there.
Solely for that reason. But if we can imagine that Canterbury had been regulated, then Canterbury could have simply written the business directly.
But it's captive because when you buy your sofa from the Unicomer shop, the only insurance that's on offer is with United Stroke Canterbury. It's not that you're offered a choice of different ones, or that the salesman says, well, I think for you in your particular circumstances, you'd be best to go with this insurer, not that insurer. It's always going to be that insurer.
Yes, but I'm not using captive in that sense. I'm using captive purely in the corporate, the common corporate ownership. My lady puts another valid, if I may say so, economic point to me. But certainly I think I can speak about our common experience. Usually retailers have a deal, either with a non-captive who simply go, if we're talking IT products, a big chain may simply not have a captive insurer at all. But it goes to insurer X and says, I sell 100,000 mobile phones a year. I try and also sell insurance. Would you like that book of business? But we will, and either they just get the book of business or it's then reinsured back into the... and it's very attractive from the insurer, be he captive or non-captive, because they don't have to do anything. They don't have to spend money on advertising. They don't have to generate a book of business. It simply comes to them.
But they usually pay then the retailer.
And in those circumstances, they may well pay some overriding commission back up the line. There's an infinite variety, as you can readily imagine, of opportunities. But if the retailer has confidence that their products will not break down all the time and will not lead to lots of claims, then they will know that it is likely to be profitable, a profitable line of business, and either they will, as my lady puts it to me, find someone who's willing to pay for it, or they will have an arrangement whereby they keep the profit in-house using a captive. There are many ways of doing it.
Because it's the commission that the insurer has paid the retailer that's what's given rise to all the problems in this jurisdiction.
Yes.
Which has been very expensive to put right.
I'm deeply conscious, I'm sure this wasn't the intention, but CPI in the UK is not an attractive idea. And I have taken instructions. I mean, this product, as you'll see, time, this product has been out there now for 30 over years.
No, I'm not suggesting...
No, I know that. But it is a very well-tested product. And the one thing I haven't mentioned at any point is that if you look at the claims, spreadsheet of the claims figures across the Caribbean for this product, you can see the meteorological data just in the claims figures. Wherever there have been hurricanes, and or in one case on St Vincent, a volcano, the claims go up by a factor of 100% or 150. So there is a completely Caribbean dimension to all of this, which I haven't mentioned, which is that people know that if they lose everything, the one thing they won't have to do is keep up the payments to my clients, and they can start afresh, hopefully to come back and buy another sofa at a discount. So this is a very genuine long-term product.
And is it right, I'm looking now at Key Documents Bundle 115, at the quoted paragraph 11 of the affidavit that was filed in the High Court, that aside, and it's B to E, aside from the deduction of a handling fee, everything received from Unicomer goes to Canterbury. United plays no role in the claims process. Unicomer has never made a claim on the policy with United, and if Unicomer had made such a claim, United would call on Canterbury to reimburse.
Absolutely, my lady. So,
right, but your main point is this goodness, wasn't this great business? It's surprising they didn't try to negotiate a better deal. Is that this is the first you've heard of this point, and there's no comparators to say whether 4.2% or 87.8% is unusual.
That is my point. And I close this part of it with this. I have to give way to my learned friend, I suspect. I've had to defend one or two real tax avoidance schemes in the past, and I don't recall ever having the accusation of commerciality and profitability made. It's always defending the scheme on the basis that it makes no commercial sense, generates no profit, except, of course, the tax saved. So it is actually, in the context of possible tax planning, it is a badge of honour that it is within its four corners a commercial and profitable product. So that's my. So we say no basis for remission, and I presume I should give way to my learned friend.
Well, what about this point about should it go to the High Court or to the...
It's a very difficult... Well, first of all, there is, I'm told, there is no local, in the sense of St Vincent, legislation which even contemplates remission. There's just an appeal on points of law, and I haven't been shown, we've looked for it, any basis for remission. This is an appeal on error of law, and the facts have been found. You, if I may say so, my ladies and my lord, you are masters of the field, and you can decide whether, on the basis of the evidence led, the outcome discloses an error of law or not.
If we were against you on that and we thought there should be a remission, what would you then say?
Well, my second embarrassment is then that, as I think you know, the fact-finding tier here didn't find any facts, and her ladyship found the facts.
Yes.
So it would, on one level, appear to be the commissioners, but having said that, that would assume that there are other facts to be found, and that would be, I would submit, is unjust to my clients. The controller's had many, many years in which to make his factual case, and we should, both of us, be obliged to now sleep in the bed, the evidential bed that we've made, and if it is to go back to anyone, then it should be to a judge, a first instance judge, but only on the question of law, which is the only question, of course, we have before the board today. I'm bound to say, I mean, no disrespect to her ladyship, it should, if it goes back, go back to a fresh mind, if I can put it that way. And that would certainly be the case were it to go back to the commissioners themselves. So that was my response on that.
To Mr. Rowe. We ought to hear Mr. Rowe.
Well, wait a minute. When are we going to hear the Section 9 Ground 3 point?
Soon, I hope.
Oh, we'll come to that. We're still dealing with the preliminary
Right, okay.
submission at the moment.
Okay, good.
Mr. Rowe, is anything else you want to say at this stage?
I take it your Lordship's talking about just the subject
Yes.
my friend's been addressing.
Yes.
We'll come back to obviously make his appeal on the other point subsequently.
Yes, issue 3
We can come back.
hived off for the moment.
Understood, my Lord. My Lord, very briefly, because really what we say is set out in our case. So far as the question of understanding what might be left over is concerned, my learned friend said that it's not a question of new evidence, and in a sense that's true. I'm not proposing that either side should. I'm not basing the submissions I make rather upon any fresh evidence. Your Lordships can see, and your Lordships can see that. I'm simply referring to the material that was before the controller, before the appeal commissioners, and before the court. But the fact remains that in that context there is a series of features. There are a series of features which are which are such as might reasonably lead one to conclude that the Section 23 criteria are met. And we set this out in our case as to why we say that is. It's really whether this is a transaction which fits within Section 23 because it's carried out by means or in a manner which would not normally be employed in the carrying out of a transaction of the nature of the transaction in question. My learned friend used a number of synonyms, as it were, for that, and talked about us saying this is a fishy transaction or there's something dubious about it. Whatever. That's one can set all that aside in my respectful submission. That's a straw man argument. The question is there any basis for saying now, no, the appeal should simply be allowed and all of the deductions permitted because we're simply not in the Section 23 territory, or is there a basis for saying we might be in the Section 23 territory and there is a reasonable ground for thinking that we are? And our submissions on that are really as per our case. I set out what the section requires to be established, and we do respectfully submit that the matters which we raise, which are not new matters, are matters which do give rise to, or could give rise to the conclusion that this was indeed a transaction falling within Section 23. The evidence about the accounts, I've checked, and my learned friend I think is right to say that wasn't explicitly cross-examined upon, and so I'm stuck with that. But it's also the case that, as the board has seen, the learned judge did address that issue quite specifically and did find, didn't quite put it in these terms, but it's pretty clear what the learned judge was saying. She found that the explanation that was given, this is all simply a mistake, 8 years of accounts showing payments to Canterbury, was not a credible explanation. Now, as far as the evidence as to what exactly happened to the money is concerned, I'm not sure I can improve upon where we are. The passage in the affidavit that the controller himself put into evidence, which is replicated in the judge's judgment, has already been alluded to, and he says there, as we saw, that the balance was sent by Unicomer to Canterbury either directly or through United. And the board
that's a big difference.
Well, it's a big difference. It's a very big difference on the case of sham. It may not be such a big difference if what in fact we're talking about is an arrangement which nevertheless falls within Section 23 because it's not the normal way of doing things. And the context which I say that is the accounts which themselves specifically talk about payments being made to Canterbury. Now,
Can you show us that is that in the bundle?
The account, oddly, the accounts themselves are not where they say that, but there is. But I can take the board to the material that gave rise to that observation on the part of the court. You should just give me a moment and find the reference. Yes, it's in Mr. Miller's evidence. I think it's page 439 in the electronic bundle.
Paragraph?
This is paragraph 7.
Yes.
So he says at the end of 6, it's not disputed that the aforementioned page exhibited to Mr. Pompey, who's the controller's affidavit, quite clearly suggests that the CPI premiums were
made directly to Canterbury.
Yeah.
Yes. And then he says, well, that's because they were incorrectly classified. So I don't think it's controversial. I think it's this that's what the accounts said, and indeed this I think is in the It's in the Appellant, my learned friend's case as well, at paragraph 56, as I recall it. Paragraph 56, our learned friends say, against this is the evidence that internal reporting, as they describe it, we would say that's not perhaps wholly accurate because these were audited, published accounts, but filed accounts. But internal reporting in the years 2006 to 2014 described the funds representing the premiums as moving directly from the hands of the appellant to Canterbury.
What is that you're reading?
That I'm reading from our learned friend's case. It's key documents, page 34, top of the page.
That makes that letter from United very odd then, at page 4.
Yes, so the letter saying that these are the premiums we've received.
Well, unless...
Query precisely what it...
Yeah.
It says November 2016. It's also dated November 2016, after the mistake had been supposedly put right.
That's quite right. That's true. Yes. So it doesn't necessarily rebut. Well, it doesn't. I say rebut the wrong word. It doesn't necessarily shed light on what was going on between 2006 and 2014. So one's left with this rather curious state of the evidence where you have the accounts saying that, you have an explanation that is offered to the learned judge, to the effect that's simply an error, and the learned judge rejects that explanation. When the matter was appealed to the Court of Appeal,
Sorry, just before you go to
Yes.
the Court of Appeal, do you say the judge was entitled to reject that explanation, notwithstanding it wasn't expressly challenged in cross-examination?
It was... I think I do say that, lady. I think about your ladyship's question carefully because I appreciate it's a delicate area. But I would the rule, so-called, about putting matters to be challenging matters in cross-examination is, of course, a rule about fairness of the trial. And the real question is, did the witness have an opportunity to deal with the subject? And the witness, it's not the position, I would respectfully submit, that if a witness does deal with a matter and says, well, this was a mistake, that the court must accept that unless counsel gets up and says that's not true, it wasn't a mistake, was it? I mean, he was saying it was a mistake because it was clear that what was being relied upon was what the accounts said, on the basis that the accounts were accurate. So it's I think the answer to your ladyship's question is yes, the learned judge was entitled to make that finding. And that finding having been made, when Unicomer then appealed to the Court of Appeal, they were required by the form of notice of appeal in the Eastern Caribbean Supreme Court to set out in the notice of appeal details of findings that are challenged, and we see that at page 187 in the main bundle. And we don't see anything there, as far as I can see, unless I've missed it, about the accounts.
This is Unicomer's pleadings in the appealing from the High Court to the Court.
Yes, my lady. Appealing from the judge to the Court of Appeal. In 2021. So one's left with that as this admittedly rather unsatisfactory state of affairs. In answer to the point that, well, I think I perhaps already touched on this. In answer to the point that, the 2 points that were, with respect, very helpfully summarised by Lady Rose a few minutes ago. One, this is the first I've heard of it, and two, there's no there's
So
no
one
comparison. One, this is the first they've heard of it.
Yes.
And two, no comparison. Well, it's not quite right to say that it's the first they've heard of it in the sense of the evidence about the extent to which the business was profitable for Canterbury was there before the court, because this is part of what's set out by the learned judge, in fact, in her judgment at paragraph 53.
Yes.
It's the same passage that Lady Simler took us to a little while ago. Which I think you can find, if you want to look, I'm not saying you have to go to it now, but I think that's to be found in the record at 480, if I recall correctly. So there we see the controller in his evidence saying in paragraph 5 of his affidavit that's quoted there by the judge, the balance after consideration of the claims consisting of 87.8% of the premiums net of commission was sent by Unicomer to Canterbury, either directly or through United. And so far as the point that there's no comparison is concerned, I accept that there's no evidence for the court that is an abnormally high level of profit for an insurer to be making on this business. But nevertheless, I submit it's in the circumstances in which we find ourselves, it's a reasonable point to make that insurance business where you only have to pay out 12.2% of the premiums is quite good business for Canterbury. Now, the point about that is not, my learned friend says, well, of course, the usual tax avoidance case involves people entering into uncommercial agreements. But the point is, from Unicomer's point of view, this was a setup that enabled Canterbury, effectively, albeit.
Well, from the group's point of view.
From the group's, yes, from the group's point of view, but we're looking at the tax affairs of Unicomer, and if one asks in that context, is it a normal thing for Unicomer to do, then in my submissions, one is entitled to question whether it is, when the evidence appears to be that there is this level of profitability on the contract for the insurer and the reinsurer.
Yes, but the answer
that's as far as I can
to the
take
question, why would Unicomer agree to pay such a huge, or to charge a huge insurance premium and then transfer all that directly or indirectly to Canterbury, is that it benefits the group because then more of the income is taxed in Bermuda than in St. Vincent. That
might be the explanation, my lady, but that doesn't, in my submission, detract from the force or the potential force of the point that when one is looking at the Section 23 criteria, one could come to the conclusion that this was a transaction which was being carried out in a manner that it would not normally be carried out in.
But if this went back to the appeal commissioners and you wanted to maintain this point as to abnormality, would you then envisage, I don't know, would you have to apply to the appeal commissioners to say, well, we want now to introduce evidence as to what different percentages there are in other arrangements? I don't know whether that's public.
Well, I would expect, I suppose, in practice, both parties would have the opportunity to say to the appeal commissioners, we wish to adduce further material on this subject so as to provide you with the assistance that you need. And it would be a matter for each party to consider whether it wished to ask the commissioners for to admit the evidence. After all, they presumably, even the first time they entertain a case, are at liberty to say this is something upon which we're prepared to admit evidence and this is not.
But Mr. Kodara's point is that it's unfair that you should get a second bite at the cherry. You've had your chance. You could have run an alternative case. So aren't you bound simply to ask the appeal commissioners to consider the position on the basis of the evidential material currently available, but also in light of the findings of fact that have been made and that are binding?
I think the answer to that, my lady, is that might well be the conclusion that the appeal commission has come to, but nevertheless it would be a matter for them to decide.
Okay,
whether
you
that
say
was-
you're entitled to ask.
We're entitled to ask. I think I can put it. I can't put it any higher than that. I don't think.
Well, that leads to the point I wanted to raise with you. It does seem that it's not, it seems pretty clear that it's not for us to decide whether Section 23 applies on an alternative basis to that which has previously been run. But it leads to the question whether it is for us on this occasion to decide whether it is open to for the point to be run at all on a new basis before the appeal commissioners. I mean, we're faced with an argument in relation to an issue of Stockwell. The question is the extent of the res judicata arising from the decision we make in this case. There may be a Henderson and Henderson issue as well arising out of that. It's a point which is not pleaded. It's a point which arises, I'm not being critical of anybody in saying this, but it's not pleaded. It's raised by a side wind. And it may just be that it's not a matter for us to decide on this occasion.
Well,
It might matter for argument before whichever body we might remit it to.
I think from our point of view, I think we would be. Well, I'm about to say what I think, but I probably ought to take instructions actually. But it's what one can. The problem the board faces is that in our submission it would be inappropriate simply to say, well, because the basis for the controller's original decision has fallen away, then we must effectively we must substitute a decision that that all of the deductions that are sought to be taken into account may be taken into account, because that would effectively involve the board deciding the issue. So one is left with the within our submission the necessity of a remission, and
So if we don't remit, we're shutting the door.
then I think yes, I think that's probably the position I ought to put to the board. I hesitate to do so entirely without instructions, and I might at some point ask your lordships whether I can, your lordships, whether we can put a short note in at the end to or afterwards to clarify the position.
I don't know, has he got somebody there that he could?
Well, not simply for that.
Oh, I see. What do you want to hear? Section 9. Okay. All right. Okay.
Should we rise for a moment just to take stock of where we are? We'll rise to take stock of where we are at the moment, and that might allow you an opportunity to take instructions as well.
See what I can do.
As the board rises, may I just give two further page references? Great apologies. The first is EB 188, paragraph 4, and what we're looking at here is the challenge in the Court of Appeal to Her Ladyship, Mrs. Justice Byers' decision. We would say that our challenge to her finding as to the payment route is more logically dealt with under the Section 66 point, and there is a fairly wide-ranging challenge in para 4 to that finding. So not specific, but certainly in terms of the route of the payment, we would say that is challenged. Yes. The other thing is actually the smoking gun. I'm not sure anyone has shown you the alleged smoking gun. An example is at EB 431. This is what my friend's been referring to, and there's another one at 433. So this is an extract from the 2009 court's financial statements, and the smoking gun is para 16. We say it's not, but that's beside the point. There's 16C, trading transactions with related parties are as follows. Trading transactions with related parties are as follows. And the third one down is CPI expense net of commission. That's what we say, and Mr. Miller said, was an error, because it was thinking of us as at an intra-group level, whereas in this particular document, this is an corporate level. So it's that one line, CP expense net of commission, 610 and 839. And you see it reproduced on.
So it's listed as a related party transaction.
Related party transaction, and that explains why we speculate, and I use that word in our case, that actually it's just an accountant thinking group when he should be thinking.
And is there a note that says Canterbury is a related party?
My lady, I do not know.
I thought I saw that something said it was.
They are undoubtedly a related.
No, I know, but in the accounts.
That I don't know, but we can perhaps find. I'm sorry to delay your rising.
It's not at all helpful. Thank you very much.
429. My lady, it's EB 429, Canterbury, top of the list. EB 429.
Thank you.
429.
Just risk of doing what my learned friend has just done also and delaying your rising, because it may be, so I don't want to hear this until we get back, but there was a question about the powers of the board. I don't know if it would be helpful for me to say something about that just before your board rises.
Yes, please.
The relevant parts of the legislation, as I said, was in the main bundle at 255. And the point I just wanted to draw the board's attention to is in section 106, right of further appeal. The controller may appeal to the High Court from any decision of the appeal commissioners. And then subsection 3, on any further appeal to which this section relates, the High Court or the Court of Appeal, as the case may be, may do various things: confirm, increase, or order the reduction of any assessment. B, make such other order as it deems fit. So one would have thought that would have entitled the Court of Appeal to remit to whichever tribunal it thought was most appropriate, and of course it's elementary that whatever the Court of Appeal can do, so can your lordships and your ladyships.
Thank you both very much. We'll rise for a few minutes. I don't know if there's anything further you want to say, having taken instructions.
I'm afraid I'm not in a position to
Right.
say anything further on instructions, my lord.
That's fine. Thank you very
Leave
much.
it where I left it.
Right. In that case, we'll move to issue 3. Mr. Cordaro.
I'm grateful. So issue 3 takes us first to section 9 and also section 86, to which I will come. Section 9, EB 1142, and our first point is to identify, if possible, if there is a grain to this section, and we say there is, and specifically the grain is in the question, or in connection with the concept of accrual. There has to be an accrual, and at 1142, section 8 is at the top of the page, and that talks of the assessable income of a taxpayer, 81A, where it is resident, subject to certain provisions, all amounts ascertained in accordance with Part Roman 4, accrued directly or indirectly from all sources, etc. And that's entirely standard in terms of international wording for income corporation taxes. Obviously, we are looking at a definition now under 9 of when income accrues. There is no ultimate financial difference that the current appeal makes, it is always going to be the same amount of money that my clients account for. It's purely timing.
Yes.
And then looking at 9.1, we can see that 9.1a speaks of earnings. That's a very clear accrual concept. And jumping to 9.1e, we have the sweep up, which obviously my clients rely on as one possible outcome, and that speaks of due and payable. And in a sense, one can see a certain symmetry between 9.1a and 9.1e, due and payable. Not paid, but certainly due and payable. And then 9.1c and d also a pair, in a sense. 9.1c talks about receipt, when it is received by him. Those are the last few words there. And d, in the case of interest, when it is paid. Insofar as the instalments, as they come in with the HP payments for the sofa, include interest, then it's quite plain that 9.1d is potentially, at any rate, a trumping provision, and the interest element of what is paid by the client triggers an immediate accrual at that point. Doesn't really matter. It's something to be decided. But 9.1d is very clear that interest...
At the point when it's paid.
Exactly, my lady.
Yes.
So our focus, as you know, is 9.1b. And what we say about 9.1b is, first of all, it is a clear statutory description of an objective situation that needs to exist in the real world. I say that because there is a hint, and perhaps more than a hint, in the decisions below and the way the argument is put, of some kind of estoppel arising from what is or isn't said in the corporate accounts filed annually. If you say you were using a particular, or you were using a commercially recognized or an IFRS, International Financial Reporting Standard, then you are deemed to be in 9.1b. That would be wrong. One can't have a statute which is satisfied by an estoppel. There has to be, and I hope this is common ground, there has to be, in reality, a commercially recognized system of accounting which ticks the boxes of being followed regularly and which is operated in connection with the keeping of the books of account of the taxpayer. It's a fairly prosaic concept, but it has to be with reference to something that is capable of ascertainment, a system which is publicly recognized and has the elements, the qualities of being a system, being commercially recognized as a system, being regularly followed. So those are three things there: being a system, being commercially recognized, and being regularly followed. And followed in what context? In the context of when it, I just quote the words, when it is credited or should be credited in the books of account. So there are two or three further concepts there. The books of account, those are referred to in the Act, in the supplementary bundle of information at, give me, page 50, electronic page 56. Do you have electronically, my ladies, my lords?
The supplementary bundle.
Supplementary bundle.
We do. It's section 86.
We have a hard copy if needed.
That's it.
It's quite important because it's also got a couple of leading cases in it.
Yeah, we've got it.
You have it?
We've got it.
So it's E
Have you?
supplemental at 56. Yes, do you, or shall Shall I share a hard copy with anyone?
No, I think
So you're looking at section
it's
86.
the supplement.
Section 86.
Yes, so what page on the supplemental bundle?
56.
Electronic 56.
Oh, yeah.
And I'm citing it,
This is section 86 of...
the same
statute.
Income Tax Act.
Thank you.
And it's headed Maintenance of Proper Records of Transactions, Methods of Accounting and Preservation of Books of Accounts and Records. And 86.1 reads, every person carrying on any business shall keep, in the English language, such records or books of accounts as are necessary to reflect the true and full nature of the transactions of the business, regard being had to the nature of the activities concerned and the scale on which they are carried out. And that's an obvious reference to, if I can use the colloquial, the books of the business, and that will show sofa let on hire purchase to Mrs. Smith on a certain date, etc., and at a certain rate. So that is the raw data. Those are the raw data from which tax returns are later created and from which also corporate filings and no doubt myriad other things. So coming just, I don't think any further reference to 86 is relevant. I mean, it speaks to of records and books of account in all the following subsections. But putting that aside for a moment and coming back to the target, which is 9.1b, what in my submission, therefore, one gleans from that is that one needs the commercially recognized system of accounting. May I apologize and say I will refer to it, it's a bit of a mouthful, as a CRSA as I go forward. So a CRSA which is followed in the maintenance of the books of account, and an interesting and possibly unique feature emerges at this point in the phrase when it is credited or should be credited. And should is unusual in the sense that it indicates a space for a qualitative decision as to whether something should or should not have been credited. And the only obvious touchstone for that is the contents of the commercially of the CRSA. So the implication is it's a closed system. There has to be a real CRSA out there. You can look at it and say, well, that shouldn't have been there, or that should have been there in the basic books. And as I say, the books of account are the raw data. They're not the tax return. They're not the corporate returns. So that is our...
So you say they're not the annual financial accounts?
No. They're referred to as accounts, as my lady has just done, but the books of account are the books. And when an auditor comes in, what he or she wants to see, we're familiar with the phrase, oh, they kept two sets of books in that business, the real books and then the others. What the auditor wants to see is the transactions recorded properly, and the transactions that should have been recorded properly, and that will be seen through the lens of the applicable CRSA. We can test this, if you indulge me to the point where I reach the IFRS, we can test that proposition by looking at the relevant IFRS. But it is that, because spinning out of the books, correctly kept, are all the forms of reporting. Insurance companies I mentioned earlier, they have special reporting. We report to shareholders, we report to the controller, etc. But the data, the raw database, has to be reliable, because one of the unique qualities of 9.1b is it's a methodology. It is not. It doesn't tell us what the answer is. The others do. They tell us when the accrual takes place. 9.1b requires us to read the CRSA and then see whether and what has been done in pursuance of that to identify the moment of the credit or the moment when the credit should have been there. So 9.1b is a pure methodology, and one of the respectful criticisms we make of the Court of Appeal, and indeed Her Ladyship, is that they were in some way beguiled into thinking that one could just look at 9.1b and know when the moment of accrual was. The answer is no. You must read the CRSA, which was in play, and that will tell you the moment of accrual. And that's exactly what we say was the error below, and the reason that we maintain that there is a critical difference between operating leases and finance leases, with operating leases being accounted for when instalments are paid, and that's something I hope to make good. So moving forward to the IFRS itself, and that we find in the bundle at E. It's two-stage. The first reference is at 2491, EB 2491. And the reason I'm taking you to 2491 is that I believe the parties are operating on the basis that the IFRS, which we say is in play, was indeed in play. That's IFRS 16. And if so, what I'm about to do is unnecessary. But just in case it isn't common ground, this is the publication which indicates that St. Vincent is an IFRS jurisdiction, if I may so describe it. And specifically, if you look at page EB 2493, in the, just above the middle, there is this: what is the jurisdiction status of adoption? IFRS standards have been adopted in St. Vincent and the Grenadines. And then if one looks at 2494, the bottom of the next page, IFRS endorsement, second entry, the auditor's report and or basis of presentation footnote states financial statements have been prepared in conformity with IFRS standards. And then over the page, same again, 2495, towards the top, about two-thirds of the way up, there is a question: does the jurisdiction have a formal process for the endorsement or adoption of new or amended IFRS accounting standards, including interpretations in place? Answer: endorsement isn't needed. New or amended IFRS standards are automatically effective when they are issued by the board for companies that use IFRS standards. At the bottom of the same page, application for small and medium enterprises. I'm unsure if my clients are such a thing, but if they are, then they are included. And the penultimate entry on 2496 indicates that SMEs that do not use the IFRS for SME standard are required to use the full IFRS standards. So that simply establishes the pedigree of IFRS. Then coming to the meat of the matter, and we say what I'm about to say, it should be decisive of the appeal, because we are now looking into, we've opened the bonnet, as it were, on 9.1b, and we're actually looking to see what's underneath it. And if we turn to 2497, one sees the heading leases, and one has to mentally remind oneself that we are entering the world of accountancy rather than law, and therefore, as lawyers, we would not regard a sofa on HP as being leased. But in the economic world that this standard is trying to deal with, that's exactly what it is. It's a bailment. And they're all lumped together. There we see 5 paras down, a para starting in December 2004, and it's simply background to the transition from IAS 17 to IFRS 16. That occurred in January 2016, and the important part of that is the second sentence. IFRS 16 sets out the principles for the recognition, measurement, presentation, and disclosure of leases. And we're looking in this case at how to recognize income from leases stroke HP arrangements in the books of account of the company. So it is to this that someone maintaining the books of account will turn, and they turn to the next page, 2499, and they see, if they are acting for the lessor, just about halfway down, they will see the index, or the contents rather, and they will see lessor, and they will see 3 headings of interest to anyone keeping the books of account: classification of leases, finance leases, and operating leases. And then turning just briefly to 2521, before I go backwards, 2521, there is an important set of definitions. We'll duck in and out of them. But at 2521, the penultimate definition on that page is of the word lease. And it says, a contract or part of a contract that conveys the right to use an asset, the underlying asset, for a period of time in exchange for consideration. So it's perfectly general, and as I've already said, to a lawyer, that would include a bailment. So that's how the word lease is being used. And if we stay on that page and look further up, we see the definition of finance lease, and that is, quote, a lease that transfers substantially all the risks and rewards incidental to ownership of an underlying asset, end of quote. As I understand it, it has not at any point been the controller's case that the HP arrangements in this case are finance leases. And we'll see if that is correct later. We have approached the matter, and we invite the board to approach the matter on the basis that the definition on the next page is the applicable one, the operating lease definition. That's EB 2523. And at the top of that page, third item, operating lease, a lease that does not transfer substantially all the risks and rewards incidental to ownership of an underlying asset. And that, we say, and for reasons that I'll develop, of course, is the correct nomenclature to apply to the HP agreements in this case.
Well, the risks incidental to ownership of a piece of furniture which has been purchased,
Yes.
would in effect be substantially transferred, wouldn't they, to the purchaser because of the terms of the hire purchase agreement?
Well, we will look, my lord, at the hire purchase agreement, and
hence the insurance.
well, the insurance, I mean, it depends on what risk. Obviously, the hurricane is covered by insurance, but it doesn't go beyond those sorts of things. The other things that are covered by the insurance are loss of your job, illness, in other words, things relating to keeping up the payments, which are, in my submission, slightly different. But the board will have to form a view as to whether the risks are or are not transferred. And hopefully, as you see the factors, they're all laid out for us, you will see how they quite rapidly stack up in favour of the operating lease conclusion. You will also be greatly assisted in my submission by the fact that the courts in Barbados have looked at a not dissimilar product and concluded that it is an operating lease and therefore should be taxed accordingly. So I'm hoping to assemble a group of guideposts, if you like, from which the board can make a confident decision. But I've dipped into the back end. Let me come to the main body and to paragraph 61, which is on EB 2513. So now we are at the heart of the case.
I'm so sorry I missed the reference.
2513, my lady.
Thank you.
Heading, classification of leases. And so again, 91B constantly in mind. So the individual who's keeping the books of account reads this. He or she sees the instruction at 61. A lessor shall classify each of its leases as either an operating lease or a finance lease. And then 62, a lease is classified as a finance lease if it transfers substantially all the risks and rewards incidental to ownership of an underlying asset. A lease is classified as an operating lease if it does not transfer substantially all the risks and rewards incidental to ownership of an underlying asset. But what I invite the board to have in mind is a classic example of an expensive piece of machinery which is needed by a commercial enterprise, and it involves itself, for example, in a sale and leaseback arrangement with a bank. It is therefore leasing the machine.
2513.
It's leasing the machine from the bank, but it's using it to produce whatever economic gains it wishes to. And that is the archetypal example of a finance lease. If we look through 63, there are 5 examples of what would normally lead to treatment as a finance lease. And none of them apply, for reasons which I will trail now and make good, hopefully shortly. The lease transfers ownership of the underlying asset to the lessee by the end of the lease term. And the answer is that's not quite what our HP agreements do. And specifically, under the HP agreements, as we will see, the ownership is transferred on payment of all the instalments. Whenever that occurs, it can occur early. If it hasn't occurred, by the end of the term, ownership will not transfer.
But doesn't the lease terminate once all the instalments have been paid?
Once all the instalments have been paid, the ownership will transfer, and that was my point, my lady. It's the triggering event is not the effluxion of time.
No, but that then brings the lease to an end, doesn't it?
Indeed, performance ceases, but
So why is that not the transfer of ownership by the end of the lease term?
The end of the lease term the HP term will be, say, 2 years, but one can prepay.
Yeah,
or
and
not.
then the lease comes to an end.
Yes. I mean, the lease will also come to an end if you don't pay, because it will be determined.
But that's not at the end of the term.
But it's not at the end of the term.
So why doesn't A apply to your agreements?
The end of the lease term, I've read, as being whatever the projected term of the bailment is.
Why?
Well, it may be that I'm misreading it, and it's a factor which can be borne in mind. But I mean, we will look at the HP agreements. It doesn't consist of very much. Let me leave a
Before you move on, under Unicomer's contract of sale, of hire purchase,
yes.
Is there not an option, does it not require an exercise of an option to purchase?
It merely requires payment It may come to the same thing, my lord. It merely requires payment
I see.
of the... let me run through these and perhaps then open the HP agreement so one can see it. The 63B option to purchase at a price that is expected to be sufficiently lower than the fair value, that does not apply.
Usually in a hire purchase contract, you pay all the instalments and then you can exercise the option to purchase for £1, say.
We don't have that. These contracts will obviously vary, but we don't have that. 63C, the lease term is for the major part of the economic life of the underlying asset, even if title is not transferred.
It's not saying, this is examples of situations that individually or in combination. It's not saying that you are only a finance lease if you meet all this A to E, is it?
Absolutely not. These are merely, as my lady says...
Isn't this absolutely a description of a hire purchase agreement?
Well, with respect, no, but these are all features that you would have, for example, in a finance lease, where a machine has been, as I said earlier, acquired with bank finance and is then leased to the user in the context of their business. That's C. D, at the inception date, the present value of the lease payments amounts to at least substantially all of the fair value of the underlying asset, which may or may not be the case. And E is the underlying asset is of a very specialized nature, that it can only be used with modification. So as far as those are concerned, we will look, perhaps we can look at the hire purchase agreement now, and that will be found as far as relevant at EB 367. So this will answer some of the questions that my lord have been putting to me. 366 is the first page. It's just 2 pages long, 366 and 367. And we see, I will just home in on the perhaps the more critical ones. Number one, I say nothing about. It's just the payment obligation, which arises on the signing of the agreement. And obviously what separates the parties is whether all of the sums which may, or indeed may not, be thereafter paid, fall to tax immediately. So do they accrue in that sense immediately? Ownership, number two, the customer may at any time pay to courts the full agreement price, set out in the schedule to the agreement, along with any payment due under clause 1 above, at which time the goods will become the property of the customer. So that's why I was saying earlier it's not linked to the end of the term, although it was put to me very properly, well, it will bring the term to an end. It will, but and perhaps I was being a bit technical, but I was merely bearing in mind that it is the payment of the full price that transfers the title. That's ownership there. And then we've got termination and, we've got care of the goods, which is unsurprising at 4. And then looking at 3.6.
Doesn't that show that actually all the risks are borne by the customer? In which case there would be no particular reason to have the clause. It's because we have an enduring interest in the state of the goods, because they may come back to us with, say, a default, or a customer may leave them out exposed to the elements. A hurricane comes along. So we say that the goods are
ultimately at our risk, so long as they remain ours. So 4, it does protect an important interest on our part. At 6, you have the insurance provision. That was really for issues 1 and 2. And then at 7, termination and repossession. On the termination of this agreement, for any reason whatsoever, the customer agrees that she will make the goods available to courts for repossession. So the overarching risk, until we get all the payments, is on us. And indeed, returning to 7, the customer may put an end to the agreement by giving notice of termination in writing to courts. And it is that uncertainty, will they keep up the payments, will they end it early, which is being addressed in the accountancy standard. If the question is, the man or woman keeping the books of account wants to know, well, do I amortize this income across the 2-year term, or do we treat it as all having accrued? It hasn't, most of the instalments, all of them apart from perhaps instalment number 1, are not yet due.
But doesn't the insurance kick in then?
Only for the risks, my lady, only for the risks that have been assured. If taking 7, a non-defaulting customer may put an end to the agreement by giving notice of termination at any time. There will be no insurance claim. They're in employment, there hasn't been a hurricane, and they just terminate. It may be that they're moving, or they've made a very responsible decision they can't keep up the payments, don't want to fall into debt, so they give us the television back. And then, of course, there are the uncertainties, which, in respect of which the insurance will not necessarily cover every option. We haven't gone into detail, but I think we have in our case, but there are different grades of insurance which insure, for example, the customer against loss of his or her job and so forth. Those won't necessarily be directly concerned with any aspect of the physical furniture, and to that extent won't touch directly on the HP agreement.
Do we have any idea as to what proportion of Unicomer's customers actually take out the credit protection?
All of them.
All of them?
All of them.
Right.
It's part of the package. But they have a choice at what level of credit protection they take out.
Does even the lowest level cover the payment of the instalments?
I believe so. I will take instructions, but I believe even the lowest level does that. But let me... So, in terms of... therefore, you've now seen the hire purchase agreement.
But do they, I see, the premium is set, the premium from the CPR, is that is paid on also as part of the monthly payment? Is that?
I believe so, yes. Everything is spread through time. So, coming back to the IFRS, and you will see what the tribunal in Barbados made of all of these points, I hope in a persuasive manner. But I was looking at page 2513, and if we could turn now to 2514, you will see, well, I didn't mention 65 on 2513. The examples, as has been put to me, the examples and indicators in paras 63 to 64 are not always conclusive. If it is clear from other features that the lease doesn't transfer substantially all the risks and rewards incidental to ownership of an underlying asset, the lease is classified as an operating lease. And then they give some examples, which I don't believe to be relevant to our case. That's 65. 66 is important. Lease classification is made at the inception date and is reassessed only if there's a lease modification. So again, the keeper of the books of account knows that there is a decision which is pretty irrevocable to be made at the start. The definition of finance leases now follows, and obviously my clients don't want to be finance leases. So recognition and measurement, 67, at the commencement date, a lessor shall recognize assets held under a finance lease in its statement of financial position and present them as a receivable at an amount equal to the net investment in the lease. Those 4 or 5 words are in italics. They lead us to page 2, keeping a finger, even an electronic one, in page 2514. If we go to 2523, we see that the net investment in the lease is a defined term, defined in IFRS 16 at Appendix A on page 2523.
Sorry, could you repeat that, please?
Yes, my lord. The answer that we see on page 2523 is that the phrase net investment in the lease is a defined term,
Yes.
defined as we're about to see, and it means the present value of the lease payments receivable by the lessor plus any unguaranteed residual value accruing to the lessor, discounted at an implicit.
Sorry, I've got gross investment discounted at interest rate implicit.
Yes, have I?
Yes, indeed. And I'm reading two things at the same time. I apologize. So that's exactly what you've got at 2523. And then to understand the gross investment, you go back to 2521, where the gross investment is set out as the sum of the lease payments receivable and any unguaranteed residual value accruing to the lessor.
So do you accept that if these hire purchase contracts are finance leases, then IFRS 16 does stipulate that all the instalments should be entered into the books at the date of the conclusion of the contract?
That is what it says,
Yeah.
my lady. So the critical question is, are these finance leases or operating leases? You will find no discussion whatsoever of that below, because the discussion below never opened this document. So you'll find no judicial discussion of it. It was the case that was being made, particularly in the Court of Appeal, but the answer, as you will have seen, I don't think I probably have time today to go through the judgments, but the answer in the judgments, both High Court and Court of Appeal, was the Section 91B per se means that there has to be an immediate accounting. So that is, I've set out the finance lease approach. Now we look at the approach that we have adopted in our tax returns, and indeed by implication in our books of account, upon which the tax returns are based, necessarily based.
And you use that phrase, books of account, as meaning something other than your annual accounts?
Oh, yes. Yes. I mean, the annual accounts are the annual accounts. They're filed at Companies House. They're seen by the shareholders. Our tax returns are our tax returns.
But the accounts must be completed in accordance with general accounting principles, including IFRS 16.
Precisely. But the accounts, or the books of account, are what need to be...
No, I'm saying the annual accounts must be.
Well, the presentation, yes, the
Yes.
presentation, that's what the IFRS says.
Yes.
But what 9.1b is aimed at, my lady, are the books of account.
Well, where are these books of accounts?
Well, they are what the accounting function within the company keeps, and what the auditors tax auditors, I'm not talking about the corporate auditors, PwC, I'm talking about the auditors from the tax office, when they're seeking to understand has 9.1b been used, they will want to know, show us the books of account, and if you are claiming to keep those regularly in conformity with a system which is commercially recognized, then what system is it? And let us see what you've been doing. And in our case, what they were doing and what is in issue, they were keeping the books of account on the basis that the HP contracts were operating leases, and I am about to show you what that leads to in terms of how to recognize and account for the income. And that is to be found at the bottom of 2516.
So they did it in the internal books on the basis that they were operating leases.
Yes.
But then when the annual accounts were drafted, the monies were put in as if they were finance leases.
No. Well, we'll see. We have one example. In the annual accounts, there was a general reference to profit, and then a subdivision in the presentation. Once again, it's just a couple of lines. There's profit, and then there's the phrase deferred profit, and deferred profit is a direct reference to the operating lease approach, which is to indicate what future tax would be, assuming that the cycle of payments continues, assuming there's no notice of termination, and so forth. And I can show you that in a moment, but I'm keen just to complete my citation here. But these are absolutely, if I may say so, core questions to the case. The page where you'll find the answer, but I'm resisting the temptation not to.
No, don't let me take it.
Is page 477. EB 477 is the document to which I will take you and which is important. So at 2516, operating lease at 81, bottom of that page, a recognition and measurement. A lessor shall recognize lease payments from operating leases as income on either a straight line basis or another systematic basis. The lessor shall apply another systematic basis if that basis is more representative of the pattern in which benefit from the use of the underlying asset is diminished. So that's what we've done. We straight line basis, as we've kept our books of account, is essentially to divide the expected lease payments, say 24 months, divide those equally over the lease term. So this is presuming a very neat future pattern, and to recognize an equal portion of each of those for each monthly or each annual period. So that's what we've done, and we've brought those to tax. This is the timing point. We brought those to tax when and if they have been received. And this is what we're arguing about. The controller says they should have all been done up front. He doesn't say anything about a finance lease, to be fair to him, because his case doesn't involve the sort of degree of examination that I'm tendering to the board. But in terms of what we've done, we have, rightly or wrongly, and the board will tell us in due course, we've sought to use para 81 straight line basis, and we have, as it were, lived with the uncertainty of not knowing when and if the money would come in.
Not knowing when and if?
The money would come in,
Oh,
the
sorry.
instalments.
You know the money will come in, don't you? I don't understand what uncertainty there is.
Well, we don't know if people will terminate early or default. Or
Well, realistically, who terminates early?
well,
Does it really happen?
I don't have specific instructions. I must confess, perhaps I took a more pessimistic view of life.
Well, I understand if you lose your job and you can't
Yes.
pay, but we're not talking about that because those are insured risks.
Indeed.
And you know you'll get the money then.
Yes.
But just on a whim, somebody decides.
Well, they may emigrate, they may sell the house, they may... there are many potential situations, but if my lady is putting to me on a sort of human level, would you expect the bell curve to have people who want to have it all the way to the end, then I would agree as in a totally unqualified manner. But this particular document, and I'm not suggesting anyone is criticising it, but it can't be criticised for not taking a more demographic, socio-economic, touchy-feely approach. Let us recall it is a document which strives to give certainty to business and to accounting in situations where there is potentially uncertainty, and whatever its justifications or not in terms of different markets, and it does duty across machinery, ships, televisions, cars, and it is in any event what we did.
So if somebody terminates early and giving you the full payment, presumably then you stop your little monthly trickle and you bring in the whole payment.
Absolutely. Or if they lose their job and we get a lump sum from the insurance company, we pay tax on it because we've had all the money we're ever going to have under that particular HP agreement. So it truly is a timing question. And the only choice, as it were, in the world of the IFRS is between all upfront and the straight line, which I've just mentioned. But all of this ground has been traversed by, in a judicial context, by others. And I wonder if I could introduce at this point, in the short time perhaps remaining, at least to introduce the court's Barbados case, which is to be found in the supplementary bundle at page 94. All you'll see on that page is income tax appeal in a square box. In that case...
Sorry, you'll have to bear with us for a minute.
Yes, of course.
I want to hear them.
And courts is the same as Unicomer, is that right? Ish.
We all remember courts of old in this country. It was a global brand. It was broken up, I think, in 07 or 08, perhaps 06. And at this time, this was courts ultimately headquartered in the UK. Today, you will see the courts brand all over the world, but they're all mini companies of their own. It's not a franchise. So the answer is this was the old UK-based courts. And this is a decision of 1st of November 2002. It's necessarily very lengthy because it dealt with a whole bunch of other points, including a CPI point, which are not part of this presentation at this moment. And I will therefore focus on what matters for the Section 9 point. Unlike the current case, the panel had the benefit of expert evidence, and so forth. But that was necessary because there was no statutory codification, as there is in Section 9(1)b, of the status of whatever the commercially recognized accounting standard was. So in the, as it were, a common law situation, it's for a party to prove what the commercially recognized standard is. Ironically, we don't necessarily come to prove that, because we are very content, if I put it that way, with great respect, if it's decided, well, there isn't really a CRS.
If it's decided,
we're content if it is decided that there isn't a CRSA applicable, or this one doesn't apply, for the simple reason that we would default to 9(1)e, and 9(1)e puts us back in the situation where we just account for the money we receive. So the irony about this case is the controller never sought to persuade the courts below that IFRS 16 applied. We seek to do so, but only if it's the operating lease. And if we fail to persuade the board that it applies, we say, well, it certainly didn't apply to this as a finance lease, but that gives us the result that we would have wanted, which is that 9(1)e applies, and we simply go on the basis of what's been received. May I very rapidly start, or may I give an indication of where the key discussion is to be found? It's to be found from page 160 of this report to page 175. So E, page 160 to 175. We don't have paragraph numbers, so if you would be kind enough to go back to 160, you will see in the middle of the page a reference to International Accounting Standard IAS 17, and you'll see that's described as concerns accounting for leases. And this is all about HP. It's all about courts HP, I should have said. There we see the, if I just quickly read it, paragraph 4 defines a lease as including contracts for the hire of an asset which contains a provision giving the hirer an option to acquire title to the asset upon fulfillment of agreed conditions. It also points out that these contracts are described as hire purchase contracts in some countries. In the instant appeals, we're concerned with HP agreements or contracts. The respondents, the tax office deponent, Cora Richards, accepted that a finance lease is similar in substance to a hire purchase agreement, but maintained that they ought to be compared, or not to be compared, as they were not one and the same. With utmost respect, we do not agree with that view. And then what follows is a wide-ranging discussion on the applicability of the relevant part of the standard, and I will perhaps come to the detail after the short adjournment, but I would commend the following now, page 171 and 172. There are 7 principles set out, which we respectfully adopt, and perhaps I can address the board on after the short adjournment.
Could you please assist us at this point by summarising what this case actually decides?
So this case decides that these are to be treated as operating leases, that therefore the instalments are to be accounted for in fiscal sense, or taxes to be paid on them when they are, if and when they are received. So this case is a complete fit with my case today, and I say it remains, it's not a binding case, but it remains highly persuasive. The accident is it happens to be courts, but it could have been anyone. And the terms of the HP agreements are indistinguishable. The
legislation?
The legislation is they have a Hire Purchase Act in Barbados. We do not in St. Vincent, but the terms of the contract, which I briefly showed you, echo the provisions of the Hire Purchase Agreement that they had before them in the Barbados case, and I'll try and make that good. It's a short point. Just in terms of progress, this case won't take very long. I've then got, subject to guidance, the Odin case, which will take about 10 minutes, Canderel, which is more substantial, the Canadian Supreme Court. So I would have thought I have another half an hour. I should have finished it.
Well, we have, of course, departed from the agreed timetable. We were supposed to finish at 12:25.
Yes.
So we're going to have to keep a very tight rein on.
I'm very conscious of that, and I will boil it down to its essence.
Thank you very much. 2 o'clock then, please.